How to pay your mortgage with negotiable instruments and transfer your home to trust. This will be a step by step process. We'll be going over the details in pretty much rapid speed. Information is free, and we will be giving you the four-step process: how to satisfy your debt, sell the property to trust and transfer it lawfully, clear the title so that there's no issue as to who's the rightful owner. And if you're in states where there's a federal Bureau of Land Management overseeing the property, how to get the patent for the land. Okay. This presentation will provide you an overview on all of these steps, step by step, so that you can have ultimate protection of your most valuable asset, your family home. So let's get started. What's the first step again? Satisfying the debt. Now, in order to satisfy the debt, what we do is draft a negotiable instrument. See, if you search negotiable instrument law, even in your state, for instance, the state of Florida, a simple Google search of a Florida negotiable instrument law will tell you that in Florida, the law is found in Chapter 7, Chapter 673, under Uniform Commercial Code Negotiable Instruments. In the general provisions section of the law, you will find the definition of negotiable instruments. So when you're drafting your negotiable instrument, you want to make sure that your instrument is created according to the description in the definition section within your state. And to the right of this, you can see Chapter 673, the example for Florida. The Part 1, General Provisions and Definitions, includes negotiable instruments, and it describes in detail what a negotiable instrument is and what must be included. So look that up for your state so that you can be knowledgeable. Next, you want to mail out that instrument. In order to satisfy the debt due to the mortgage company or the bank, if that's your situation, you must present or send the instrument to the company. You must use certified mail. That's recommended because you would need to prove that you presented the negotiable instrument. So you must mail the instrument via certified mailing. Keep a copy of the receipt and the tracking number. This will serve as evidence if and when you need to prove that the instrument was presented and received by the party. Now, what's the significance and the legal effect of presenting a negotiable instrument? Well, a debt is satisfied upon presentment of a negotiable instrument. It's totally satisfied up to the amount that the instrument was worth, and that is determined by the face value of the instrument and the number that is drawn on the instrument. In the event that the recipient dishonors, denies, or refuses to accept the instrument, the debt is technically discharged according to state law, and it is no longer valid. For detailed laws on the negotiable instruments and the rules regarding presenting the negotiable instruments, just refer to the negotiable instruments law within the state that you are currently located and your property is located. For instance, we found earlier that Florida's negotiable instrument law is found in Chapter 673 of the state's commercial code. Within that chapter, you could find that Part 2 contains information on transfer of negotiable instruments. So at the top of this, you can see Part 2, negotiation, transfer, and endorsement. Now, that came from the Florida statute, the Code of Florida, and it will be similar in your state. Step 2, sale to trust. Now, once you've presented the negotiable instrument to the mortgage company and or the bank, that debt is totally satisfied. Now, you want to make sure that you can protect that property, so you're going to sell it and or transfer it to a trust, but not just any trust. We're going to form an estate holding, irrevocable trust. So, asset protection with irrevocable trust is pretty solid because irrevocable trusts provide asset protection based on the fact that once the asset is transferred to a revocable trust, it's no longer considered owned by the individual who created it, but by the trust itself, right? And what's very important about transferring it to the irrevocable trust is the asset is now protected against third parties, including your mortgage company or a bank. If they ever try to come against you personally, that asset currently would be transferred to the trust. So it's not capable of being um, taken or received by any third party because that is an irrevocable trust and that cannot be changed. So after it is transferred, well, the process. Let's go through the process of transferring it. the quick claim contract. We will do a quick claim deed, which is a legal document used to transfer property ownership from one person to another party. And it doesn't give any warranties or guarantees about the title. It's just a really swift, efficient way of transferring title to a property, right? Yet, because it doesn't give any guarantees or warranties about the title, we've got a step that we recommend after this. Yeah, you would file that quick claim filing, right? File the deed at the local county recorder office in order to get the property transferred in public records. So, yes, you get the quick claim contract signed, sealed, and delivered, right? And that will be an agreement between the trust that's purchasing the property from yourself, right? And then you'd file that at the county recording office. And what's the legal effect of transferring and recording the property to a revocable trust? Well, as stated earlier, the property is protected from your personal creditors, which can include the mortgage company and or bank, once the property is transferred or sold to the irrevocable trust and the deed is filed at the local county recorder office. This provides protection in an event that a third party attempts to take the property from you for any reason. More specifically, spendthrift clauses in a trust uh, prevent creditors of the beneficiary from reaching the assets held in the trust to satisfy their claims, while discretionary distributions allow the trustee to distribute income or principal to the beneficiary only if the trustee deems it necessary. So that further shields the assets from creditors. After step two, we move on to step three, which is clearing the title. Now, the filing of a quit claim deed is proper notice of the property transfer. Yet, as stated earlier, due to the fact that a quit claim deed does not make guarantees about the title may be clouded and capable of being disputed. Not saying that it is clouded or capable or will be disputed, yet to make sure that you have the most ultimate ownership, we recommend doing a quiet title case. Initiate a court proceeding to clear the clouded title and get court evidence that the trust is lawfully bona fide 100% owner of the property. And you do that by initiating the quiet title case in that jurisdiction where the property is located. The legal effect of a successful quiet title case. See, a successful quiet title action establishes clear, undisputed ownership of a property, and it protects the owner and their heirs from future challenges to ownership. It resolves ownership disputes, clarifies title, and ensures a clear chain of ownership for future transactions. So you want to make sure that you got that quiet title case because that is a documentation from the courts stating that the trust is 100% owner of the property. After that, step four, final step, patent the land. Now, for property that is held in allodial tenure, it is recommended to get your official land patent directly from the Bureau of Land Management. Now, this is only applicable to parties who have properties in jurisdictions where the property was held and registered with the Federal Bureau of Land Management. If in your state there is no Federal Bureau of Land Management overseeing the properties, this step would not be relevant to you. A land patent is the only form of proof of absolute title to land in the United States of America. Now, if you're the rightful owner of property held by the federal government in the Bureau of Land Management, you have this option. The legal effect of obtaining a land patent is very efficient and very effective means of defining the fact that you are the absolute and perpetual owner of the property. As stated here, obtaining a land patent grants the patent owner absolute and perpetual legal title to the land described within the patent's boundaries. This title is considered supreme and irrefutable, as it means that all prior claims to the land have been reviewed and resolved. Now, if you need any support in this process, we have templates, notices, disclosures, filings, court strategies, and provide a one-on-one private consultation for only $500. Or if you need help completing the entire process and step by step walk you through everything and provide you with the proper documentation every step of the way, we do that for $3,500. Now, if you're interested in any of these options, simply send a Zelle payment to the email there and follow it up with an email that has a screenshot of that Zelle payment so we can get you started. But thank you. You now know how to complete the process to having ultimate control of your home. And you can follow these steps and do it on your own or get support from us. Either way, success to you.